Sam Seder on the Majority Report. Emma Vigeland out today, although we will be hearing from her, I believe, later in the program. Returning to the program, Chase Strangio, co-director of the ACLU LGBTQ HIV Rights Project and plaintiff's attorney in U.S. v. Skrmetti, where the ACLU, and correct me if I'm wrong, joined with the United States. It was filed under the Biden administration in suing the attorney general, really the state of Tennessee, over their ban on health care for trans children, or really, more broadly speaking, anyone with any type of gender dysphoria or a whole host of other issues, it seems to me. But characterize the case for us, Chase, and welcome to the program.
Well, thank you so much for having me. And you're right that this was a case that the ACLU and Lambda Legal filed against Tennessee on behalf of 3 adolescents and their parents and a Tennessee doctor who provides this medical care to both transgender and non-transgender children. The United States under the Biden administration also joined the lawsuit, and we both argued that Tennessee's law violated the equal protection rights of transgender young people by allowing treatments if those treatments were consistent with an individual's sex, but banning them when they're inconsistent with an individual's sex. So we raised the argument that this was a law that discriminated based on sex and transgender status, as well as infringed the rights of parents to direct the medical care of their minor children. And we brought that case up through the courts at a time when adolescents in Tennessee were losing access to this medical care. Their parents, who had spent years trying to understand their children, how to best treat them, had their judgment displaced by the government of Tennessee, were scrambling to find medical care. And so in March of 2023, we filed a lawsuit against Tennessee, and that is ultimately what became the case of United States versus Skrmetti at the United States Supreme Court.
Now, the fundamental question, well, there was a couple questions, and it feels to me like, from what I've read, that the Roberts Court, the 6-3 divide, which I think people have come to sort of anticipate, really skirted the fundamental questions here in some ways, right? I mean, the fundamental question is whether this is a case of sex discrimination as defined by court precedent. And so under what statutory framework does that become the question? And then let's delve into sort of the way the court sidestepped really an assessment of that was consistent with what prior court cases have been.
Yeah, so it was a question brought under the Equal Protection Clause of the 14th Amendment to the U.S. Constitution, and that amendment says that the states shall not treat any person differently, and it's to be subject to differential treatment. And our argument was, look, this is a law that treats people differently based on their sex, and that the reality is that if you are someone who's assigned male at birth, you can get testosterone treatment in order to undergo a typical male puberty. If you're assigned female at birth, you cannot. Straightforward case of sex-based discrimination. That's 50 years of precedent of this court have held that when governments discriminate based on sex, the government has to come forward with a sufficiently strong justification for that discrimination. And
that's what we know as heightened scrutiny.
Correct. That is what we know as heightened scrutiny. And the reason for heightened scrutiny is because there is, generally speaking, quite a bit of deference that courts show to the legislature. However, if the legislature gets into the business of treating people differently because of characteristics that have been the basis for discrimination in the past, we want the judiciary to come in with a more scrutinizing eye. And for 50 years, when there has been sex discrimination by state governments or by the federal government, the court has applied heightened scrutiny. And here, in essence, as Justice Sotomayor says in dissent, the majority had to distort both logic and precedent to reach the conclusion that this law, which on its face mentions sex 18 times, was not sex-based discrimination.
I mean, this law specifically says that its purpose is to encourage minors to appreciate their sex. It says it is to prevent people from becoming disdainful of their sex. And so, like you say, you could have all of the treatment that is that could be potentially prescribed as long as it is in furtherance of maintaining your gender with your sex. I guess it was United States v. Virginia that basically said all gender-based classifications warrant heightened scrutiny. So that was, but they sidestepped even the question of scrutiny, didn't they? Like they could have limited their ruling to the question as to whether this deserves heightened scrutiny or not, which is just a higher level of standard in which you need to have a state compelling reason by the state. And so theoretically, they could have said, this deserves a higher level of scrutiny, send it back down to the courts. If the lower courts find as a finding, I guess, of fact, that there's a reason for the government to have a higher set of scrutiny. I mean, there's a more compelling reason by the government to do this, then that's the case. But they went further than they needed to, in other words.
Yeah, I mean, I think in one sense they did, and in one sense they didn't. I agree that all they needed to do was answer this question of whether it was heightened scrutiny or not, and that their precedents clearly, in our view, mandate the finding, the determination that this was a sex-based classification warranting heightened scrutiny, and then send it back down. The lower courts are in the business of making those determinations, weighing the evidence with the asserted justifications. Instead, the court answered the question. They just did it in a way that feels disingenuous and defies really any sort of logic. They said it's not a sex-based classification, and therefore heightened scrutiny doesn't apply. They did not say that for some other reason heightened scrutiny doesn't apply. They determined that this law, in their view, did not draw distinctions based on sex. And that, to me, is what's so nonsensical about the decision. I think it is more narrow than if they had said something along the lines of, it is sex discrimination, but only in this context do we not apply heightened scrutiny. They left intact United States versus Virginia. They left intact the 50 years of precedent saying all sex classifications warrant heightened scrutiny. They did so, however, by looking at this law and offering a nonsensical reading of it.
I see. And that would place like Amy Coney Barrett's dissent, or I should say concurring opinion, where she actually would have said that this was that this does not trigger heightened scrutiny.
Yeah, so there's three justices that would have gone even further. And Justice Barrett, in her concurrence, she agrees that it doesn't discriminate based on sex. And she sort of goes out of her way to say, even if it did discriminate based on transgender status, I don't think discrimination against transgender people as such warrants this type of scrutiny by the courts that we apply to discrimination based on race, based on sex, based on national origin, based on what was called legitimacy. And so she's going out of her way to signal that she's prepared to green light all sorts of discrimination against transgender people. The majority's opinion makes clear that it is only addressing this very narrow context.
All right, let's talk about the implications of this, specifically for young people in Tennessee and perhaps in other states across the country, maybe specifically, maybe not even perhaps across the country. And then for transgender folk who are over the age of 18? Because it seems like this also opens up the door for bans against any type of healthcare for transgender people.
Yeah, I mean, so I think what's so hard about this, what's been so hard about the last 2 years, is that people like our clients in this case, the Williams family, have had to uproot their lives. They've now traveled to four different states to access healthcare for their teenage child, and the reason for that is because their government has come in and said that you cannot make this one and only one decision for your child with respect to medical care, because we think we know better. And they did not regulate the medical care. They did not start by studying the medical care. They just, from one day to another, completely banned it. And that's the same thing that has happened in half the states in this country. And I think for parents, and I'm a parent, and I just want people to think about what it would feel like if your child was suffering and you didn't know what to do for many years, which is the case with all of these families. They're calling experts, they're doing research on the internet, they're trying to figure out what to do, and they finally come up with a solution. They see their child start to come back. They start to thrive from this medical care, which has been prescribed for this purpose in the United States for over 20 years. And because of changing political realities, because of a heightened scrutiny in the bad sense of this care, all of a sudden it's unavailable in their home state. All of a sudden, everything that they started to solve in their lives is at risk, and that's what's happening here. And the reality is the very same states that are banning this care are the states that during the pandemic said parents have a right to send their kids to school without a mask. Parents have a right to ensure that their children are not taught about racism in schools. Parents have a right to stop their kids from getting vaccinations. Now, we have the same states saying, but you know what parents don't have a right to? To provide gender-affirming medical care to their minor children. And it's devastating for these families, and they're scared, and their kids are scared, and their kids are internalizing all of this rhetoric that's coming from all levels of government, including the federal government, quite aggressively right now.
What are the implications of this ruling for trans care writ large? I mean, obviously there are going to be states that are going to protect care for trans folk. In those states that have passed, and I think we're 23, some form of restriction on gender affirming care for minors. Legally, do the states have room now to do this for people who are over the age of 18?
Well, we're starting to see states do that even before this decision from the Supreme Court, and that's one of the reasons why we've been fighting so hard. You know, some of the states that ban this care, Oklahoma, Florida, South Carolina, started to ban public funding for this care for adults. So Medicare, Medicaid, state Medicaid, state employee benefits, all of a sudden losing that for adults. I think we can anticipate the escalation of care for escalation of bans and to reach care for adults. I don't think this decision necessarily greenlights that as a constitutional matter, but I do think it emboldens the actors who want to cut off healthcare for transgender people to do so. The court was clear that at least as to their holding that the law did not discriminate based on transgender status, that was based on the fact that it was limited to minors. Now, I can't say for sure that the next case that comes up before them that deals with adults, that they're going to rule differently, but there was at least some limiting language in there about the fact that it concerned care for minors. I also think that were the federal government to take this action, depending on how they would try to do so, there would be other arguments available, and especially if we see President Trump seeking to do something via executive order that would violate the separation of powers in some way, whether the president might try to overstep into the role of Congress. There would be other legal avenues available to challenge that. So certainly this is not a decision that answers questions under distinct legal theories that might be implicated if the federal government were to act. And we know right now, Congress, in the budget bill, both the Senate and the House version have a ban that would be national in scope on Medicaid coverage for gender-affirming medical care for people of all ages. An overwhelming majority of trans people rely on Medicaid because of discrimination in employment, in housing, in education, in healthcare. And so when you have a community that is disproportionately living in poverty because of discrimination, disproportionately therefore relying on Medicaid, to have Congress come in and suggest that they're going to ban a form of medical care under the Medicaid program, that's going to have a serious impact on trans people. So we're obviously watching that as well.
Is that provision, I want to get back to just the federal ban in a second, but is that provision in Medicaid, which is in the reconciliation bill, do you know if that has been subject to the Byrd rule scrutiny? In other words, on its face, it sounds to me like something that would run afoul of the Byrd rule, which says that not only does everything in a reconciliation bill have to impact the federal government's budget, but it has to be for the purpose of impacting the federal budget. And it sounds to me like it's very difficult to pick out one subset of medical care that Medicaid provides and say, we're doing this for budgetary reasons. It's absurd.
Yeah, especially when it's, thinking about hormones, they're disproportionately provided to non-transgender people for other purposes. It's being reviewed by the parliamentarian today. So that question, we will get the answer to imminently, today or tomorrow, but likely today.
And so the prospects of there being a federal ban are probably low, at least in terms of legislation, because of the need in the Senate to have 60 votes to move that question forward. From an executive order, less so, but your sense is that there's a lot more legal grounds in which to contest that if it is a specific executive order, whether that in regards to Medicaid or some broader ban.
Yeah, absolutely. I think there are legal mechanisms to challenge executive agency action, especially executive orders, if they seek to ban medical care or even restrict medical care, depending on how they seek to go about doing that in the aftermath of Skrmetti. And we currently have a lawsuit challenging one piece of one of President Trump's executive orders that sought to coerce hospitals and other medical providers to stop providing gender-affirming medical care to transgender people under the age of 19. And that case is ongoing and includes the argument that the president is exceeding his constitutional authority by threatening federal funding to state institutions in that manner. So that litigation will continue. Litigation against adult bans will continue. There are theories available. But of course, it is troubling when the Supreme Court acts in such a way that so obviously distorts the language of a statute, the purpose and precedent related to the Reconstruction Amendments. And this is a court where we're about, to continue litigation over another quintessential piece of the 14th Amendment, which is the birthright citizenship provision. And so if this court is so willing to move away from these critical constitutional protections, as they did in Dobbs, as they did here in Skrmetti, as they are continuing to do, I think we have to ask ourselves, what else is coming? And are we going to see these attacks as interconnected, or are we going to continue to let these powers divide us?
That's a great point. And I'm fairly confident these are going to keep coming. And that assault on those post-Reconstruction amendments are going to, I think, just continue to build on themselves. Trey Strangio, co-director of the ACLU LGBTQ and HIV Rights Project. one of the plaintiff's attorneys in the Skrmetti case. Thank you so much for your time today. Really appreciate it.
Good to see you. Thanks so much.
Hey, folks, don't forget to hit the subscribe button and check out our daily show. We do it every day at 12 p.m. Eastern for about 2.5 hours. We even take phone calls. You should check that out.